We have one final argument set, and that is State versus Duffy. Its case number is 18CA011342 and 18CA011349. Counsel for both parties are present. Each will have 15 minutes to present their arguments. Appellant, you may reserve up to 5 minutes for rebuttal. I'll keep track of the time, so if you're going to reserve time, let me know, and I'll keep you advised as to where you are. And we use initials for victims and children's names, since the arguments are recorded and put on the court's YouTube channel. We use the front podium, so we ask that you stay at the podium and keep your voice up. And finally, we have read all the briefs, and we are prepared to proceed if you are.
Very well. Thank you.
Thank you.
Mayor, if I may reserve 5 minutes for rebuttal.
5 minutes, very good. Thank you. You may proceed.
Your Honors, this time may it please the court. My name is Attorney Jason Harles, to represent the appellant in this matter, Ziaire Duffy. On May 27, 2015, Mr. Duffy entered pleas in multiple cases, that being 8 case numbers. In total, part of the sentence was that he was to be sentenced to prison for 58 months on 2 case numbers, 18CR089550 and 15CR091286. Those 2 cases were sentenced, as I said, to prison for 58 months. The remainder of the 6 cases, he received community control sanctions. At that time, the court made requisite findings to put him on community control sanctions to commensurate with the those 6 case numbers, including that community control sanctions would not demean the seriousness of the offenses. After serving nearly 600 days in prison, Mr. Duffy then filed for judicial release. The first judicial release motion was denied, and then the second motion was eventually granted with the stipulation that Mr. Duffy attend the CBCF immediately upon release. Mr. Duffy did attend the CBCF, however, he was unsuccessfully terminated. Making the court aware that he was unsuccessfully terminated, he was still continued on community control sanction by way of his judicial release sanction at that time. It's my argument that community control sanction should have been told, perhaps because he was on judicial release versus on straight community control. However, when it came time for the merits hearing, I was appointed the day before, actually the night before the hearing, here to court for the sentencing and the imposition of probation revocation hearing. At that hearing, Mr. Duffy received 13 years, 4 months for a violation of probation on all 8 cases, including the 2 judicial release cases. It's my contention that
Now, since the time he did not complete CBCF, he also was arrested for additional charges that were all dismissed. Is that correct?
at the time of this appeal, Your Honor, they were all dismissed. At the time of the imposition of sentence, they had all been dismissed. I'm not sure exactly which charges have since been indicted federally, but you did have some charges that were indicted federally. Under my first assignment of error, I urged the court to find that the trial court erred when it imposed the maximum reserve sentence on all 8 cases based on the technical violations. The distinction I seek to find is that Mr. Duffy hadn't been convicted on any of those new cases. I understand that there is case law that finds that violations that are technical in nature by way of positive drug tests could possibly constitute more than a technical violation. However, in this case, it's unclear as to what violations he was exactly being violated on because of the multiple hearings. Going through the record, you see that the hearings were continued, different sanctions were imposed. He was ordered to required to get drug testing, drug screening to figure out which method of treatment he needed. He completed some of those before this incident came about where he was finally arrested. The real catalyst to him being arrested, or to the probation violation being brought, was that he was arrested on some new charges. Again, at the time of the hearing, those charges were pending. Shortly thereafter, they were dismissed. brings me to my,
Isn't it the nature of the conduct that the court considers, not whether or not it's a conviction? The nature of the conduct of getting arrested on these new charges.
Ron, I believe that it's the nature of the case law that distinguishes between technical violations and fines is the nature of the conduct. I was referring to drug tests, failed drug tests, and it's my understanding that that failed drug test is criminal in nature, not because of the drug test, but because in order to do the drugs, you have to possess the drugs. Therefore, we knew that you possessed drugs at some point, i.e., it's criminal in nature. Whereas a pending case cannot be considered under 2915 because it doesn't constitute a new act until there's a conviction. I believe that would be a violation of my client's due process rights.
So are you saying the state can never go forward with the probation violation hearing with facts of the pending case, as long as that case is still pending?
I believe that there has to be some level of fact-finding to occur as to those new facts or some type of rebuttal available. I do not think that they can proceed without a conviction. If there's solely charges that have been pressed against a client, I don't think that the court can move forward with that probation violation solely based on the fact that there are new charges.
You don't think they can bring the witnesses from the new charges in to testify?
Again, if there were that level of fact-finding, I believe that there would be due process there, and therefore it wouldn't be a violation, so that would be a possibility at that point. But in this situation, that is far from what happened. Again, I was pointing the night before, 8 cases is a lot to wrangle. It's a lot to go through even in hindsight to get through all these cases and find out what was charged where, what the fact-finding was done.
Just out of curiosity, did you request a continuance?
I did, Your Honor, and it is mentioned at the beginning of the transcript from the hearing date. It wasn't that big of a deal. That day, the courtroom was full of media and other representatives from law enforcement. I requested it off the record, and then the judge acknowledged that I requested it on the record, both for the purposes of permitting me to prepare better for this hearing, being that there was such a substantial sentence that was about to be handed down. I was made aware of that prior to the hearing. And the fact that I believe that my client has mental health issues that the court was aware of. And as I indicated in my court assignment of error, I believe that the court failed to grant my client the necessary right to due process in permitting him to establish whether or not he was competent to go forward with that hearing, and again, aiding the defense of any fact-finding that needed to occur prior to the hearing. And I find that to be important because time was of the essence. I had less than 24 hours to prepare for the hearing and less than 24 hours to discuss these matters with my client, to get through 8 cases and establish what happened where he was sanctioned along the way, and what exactly was going on with his behavior at that time.
So you had first met him?
Correct.
The night before?
Actually, I met him that morning.
And you raised the competency issue based on your interactions with him or based on your review of the case history?
Based on my interactions with him, along with, I used to work for his prior counsel, so I had some insight as to who he was and what had happened there. I was also made aware by several attorneys in the community of his biological father's mental health issues, as well as the judge indicated off the record that he also was aware that his father at least had very serious mental health issues.
Counsel, is there a difference between mental health issues, albeit serious ones, and competency for purposes of legal analysis?
Certainly, and I think that in this case, I'm using the terms interchangeably, but there are certainly differences. I think the competency is what we're really gunning towards here, because again, it's competency, and then it's his ability to aid in his defense and explain things to me rapidly that occurred over such a long period of time. Additionally, I just want to point out to the court that again, I think that there's a difference that needs to be distinguished between the judicial release cases and the community control sanctions. I think that Mr. Duffy was placed on judicial release at that time that he was in prison. The time on community control was told. And I think that when he was put on judicial release, the imposition at that point should have been the imposition of the judicial release cases, and the community control sanctions possibly could have been extended out and told as they were when he originally went to prison at that time. I think that
Back up a second. I know that the judge did separate journal entries and made the separate findings based upon the level of the offense. Are you telling me that the community control sentences were told, or was he technically on community control while he was in prison?
it's my understanding that while he was in prison, that the community control sanctions were told at that point. By function of him being in prison, he can't be on community control sanctions. And I urge the court to find the same thing, that while on judicial release, he can't be on community control sanctions. Therefore, it would warrant the imposition of the remaining prison term under the judicial release rather than the imposition of all sentences on the remainder of the 6 cases plus the judicial release imposition.
Counsel, you're at 5 minutes now. I think you requested 5 minutes. Do you want to continue or do you want to stop?
I'll stop at this point.
All right, you'll have 5 minutes for rebuttal then.
Thank you.
15 minutes, counsel.
Good morning, Your Honors. May it please the Court, Lindsay Poprocki on behalf of the State of Ohio. Ziaire Duffy, in his appeal, primarily challenges his sentence on revocation of his community control. The State would submit that the term of incarceration imposed upon Duffy by the trial court after his community control violations was proper. As his counsel has indicated, in May of 2005, Duffy entered guilty pleas to the indictments in 8 separate cases which were pending against him, which included pleas to 19 felonies and 11 misdemeanors. The felony counts ranged from felonies of the 5th degree to felonies of the 3rd degree. Duffy was ultimately sentenced to an aggregate of 58 months in prison on 2 of his cases and was sentenced to community control sanctions on his remaining 6 cases. At the time, the trial court ordered the prison sentence to be served consecutively and also put Duffy on notice that a violation of his community control sanctions would lead to the imposition of the stated prison term in each case, which would be served consecutively to his other cases. He was subsequently granted judicial release, as his counsel has indicated, and violated. Those violations led to the sentence that he is appealing. First, contrary to his suggestions, Duffy's violations of his community control sanctions were not technical violations, which would have limited the trial court's authority to impose a sentence of either 90 or 180 days on Duffy for his 4th and 5th degree felonies. Here, the sentencing caps for technical violations did not limit the trial court's ability to impose the maximum reserved sentence on Duffy's cases because his violations were criminal in nature. Duffy cites to his failure to complete the CBCF, his failure to report to probation, and his failed drug screenings as examples of technical violations of community control. But he was also charged with multiple criminal offenses during March and May of 2018, some of which were felonies. Ohio appellate courts have held that a technical violation of community control for purposes of the sentencing caps in 2929.15b are violations that are not criminal in nature. In his merit brief, Duffy conceded that he was charged with new felony criminal offenses while on community control and out on the trial court's capias, but seems to argue because those charges were ultimately dismissed that he committed only technical violations of community control. This is simply not the case. Contrary to Duffy's argument, appellate courts have previously held that it is the nature of the conduct that is important. Sentencing caps do not apply where the offender engages in conduct constituting a new felony offense, because it is the activity itself that is considered and not whether a formal charge has been issued or a conviction obtained. The state cited to several cases in its brief that hold for that proposition. Duffy was in fact charged with new felonies while on community control, and irrespective of a conviction, the criminal nature of his conduct went far beyond mere technical violations. Specifically, while on community control, Duffy was arrested by the Lorain Police Department, charged with unlawful restraint, possession of cocaine, domestic violence, and disrupting a public service, after which he failed to report to his probation. As a result, the trial court issued a habeas for his arrest based on the new charges he was facing. Then, while out on the court's habeas, Duffy was charged by the Elyria Police Department with 2 new felonies. Several days later, Duffy was arrested on the trial court's habeas. While police were attempting to arrest Duffy, it's alleged that he was accused of ramming his vehicle into a police cruiser and then led the police on a vehicle pursuit. Again, this conduct was criminal in nature, and the reserve sentences were properly imposed.
Counsel, I don't know that the appellant here is disagreeing with some of the stuff you're saying, but he is arguing, at least here this morning, in answer to Judge Callahan's questions, that that there was an adequate fact finding, that if you're going to charge with an unindicted or a non-conviction or whatever, then you have to have due process and have to have some evidence presented of what the conduct was, how it was wrong.
I think the probation officer did testify to that conduct, and he did not make that argument in his merit brief that there was not adequate fact finding. He simply, in his merit brief, argued that these were technical violations of, and did not constitute, or that the sentencing cap should apply to limit his sentence to 90 or 180 days for the 4th degree and 5th degree felonies. As to the continuance that Duffy mentioned, he requested a continuance to obtain a mental health evaluation. Whether to grant, and we submit that there was no abuse of discretion in denying the continuance here. A continuance to be granted for a competency evaluation is within the sound discretion of the trial court and must be determined on a case-by-case basis. First of all, in a revocation hearing, a defendant is presumed competent unless the issue is raised before or during a probation revocation hearing, and a substantial basis for the suggestion of incompetency must be demonstrated. Here, despite Duffy's request for the continuance, there was simply no evidence before the court which warranted the investigation into Duffy's competency. Duffy's counsel mentioned several indications of his mental health issues, but I don't believe that much of that was in the record before the trial court. The record is very slim on the request for the continuance and any mental health issues that Duffy may have been suffering from. The record clearly reflects that Duffy was present at the merits hearing and was appointed counsel. He had the assistance of counsel, and the record clearly reflects that Duffy did not at any time during the proceedings raise his competency to participate in and or to understand the proceedings and or their results. The transcript also indicates that Duffy was able to follow the dialogue during the hearing, and he even advocated on his own behalf at the hearing. He was presumed competent at the time of the merits hearing and did not demonstrate a substantial basis for the suggestion of his competency. any questions?
Yes. One of the assignments of error had to do with the consecutive sentences.
Yes.
Is it the state's position that the statement in the entries, I believe that these were the non-prison cases to start with, that said if you violate, you'll get consecutive time? Is it your position that that is good enough for the court to then go and impose consecutive time later? Which it did, correct?
It did impose consecutive sentences at the revocation hearings. I believe that at the revocation hearing, the court also has to make consecutive findings.
Okay, and did it in this case?
We're submitting that the findings that the court did make were sufficient.
Okay. Thank you.
Okay. Anything
He
further?
didn't use the exact, as I recall, he didn't use the language to mean the seriousness of the offense, statutory language. So you're arguing that what he said substantially complied with the statute?
While not ideal, we're arguing that it was sufficient for this court to discern that he did make the sufficient findings. And I cited to a case, State v. Berry, where somewhat similar, it could be analogized to the language that was used in State v. Berry, where this court found that while not ideal, the language could be discerned to make sufficient findings.
Anything else, Judge Kelly?
Thank you.
Judge Carter? Thank you for your argument. I've got you with full 5 minutes for rebuttal.
Brief with this, I just wanted to clarify a few points, Your Honors. First of all, again, to the criminal nature versus the technical violations, I am pointing out that the lack of fact finding was an issue in this matter. Also, criminal nature is, again, I think the language from all those cases centers around the fact, again, someone did drugs, showed positive on tests, therefore they possessed it at some point, and that's criminal, not so much that any new allegations or crimes are automatically criminal in nature.
Did the probation officer testify about the new crimes?
Your Honor, the probation officer did testify, Jen Parker did testify related to violations. However, when speaking about the new allegations, she had very little knowledge of the allegations other than what had been tossed around in the back in judges' chambers with regard to those violations. At that time, again, there was a lot of media in the courtroom.
For this case?
For the imposition of the sentence, Your Honor. This case had an issue where a federal officer was accused of using a racial slur while arresting my client, and I believe that fueled some of the media issue around it. Everybody was sort of in a frenzy that morning trying to get this done, and again, I asked for the continuance off the record. Perhaps I didn't belabor the reasons for the continuance on the record because the judge indicated off the record he would deny any such request. But I believe that in the transcript it shows that he did acknowledge that he discussed it off the record and that he felt that he had to move forward at this time.
Did he say why?
I'm sorry?
Is that in the record, why he moved forward at that time?
He never really gave a reason. I don't think in the record. I believe that at the time the feeling was that there was so many people here from law enforcement and media that, and considering that allegations that were swirling about, that he felt that he had to go forward at that time. I believe there's some acknowledgement again to the maximum consecutive sentences and whether or not he made the proper findings. I think that the judge makes a comment at some point that my client is a thug, that he's a menace to society, and needs to pay, and I believe that that's the statements that the state is referring to with regard to the findings that they find sufficient. Again, I urge the court to find that those findings are insufficient. The fact finding didn't occur, so to have the judge comment or to just simply say that you're a menace to society, I believe it's improper. I think that the language that was necessary for maximum consecutive sentences needed to be laid out because of the fact that, again, he was given prison at one point for 2 cases and community control sanctions, which would require the opposite findings on the sentencing guidelines to permit him to have those community control sanctions. So I think that whether or not the seriousness of the offenses was demeaned by the sentence. I don't think there was any inquiry into that. I think it was more of a visceral, from a gut reaction to the allegations that my client had been accused of. That, I would just ask that court seriously consider the sentence that was handed down in this matter, because I do believe it was improper. Thank you.
Thank you both for your arguments today. The court will take this matter under advisement as well, issue its decision in due course. The clerk reports will mail you each a copy of the decision on the day it is released. You can check the Supreme Court of Ohio's website, where the opinions are also posted. We appreciate your argument.